Good afternoon, everyone, and welcome to the third week of online mini lectures, class 26 on civil liberties. This is, I guess, week 10 in the syllabus. We're starting our last unit of content for the semester, looking at civil liberties, civil rights, questions of justice. So we're going to be talking about kind of how the American democratic project has upheld, not upheld, evolved to realize its democratic and republican values. So today we're going to be focusing on civil liberties. Our goals for today are first just defining civil liberties, getting a sense on what we mean when we're talking about civil liberties. We're also going to be identifying the civil liberties protected in the Bill of Rights and describing the politics and policy of civil liberty protections, looking at these as political objects and political areas of contestation and conflict, rather as much as they are kind of declarations of rights. So what are civil liberties? Civil liberties, as your textbook defines it, are limitations on government power intended to protect freedoms that the governments may not legally intrude upon. And it's important to note that the way that the Constitution phrases these civil liberties is that these are liberties that are ascribed to persons, not citizens, which means that the Constitution has a fairly broad conception of who benefits from these civil liberties. And that means that these civil liberties can be these civil liberties also protect non-citizens, whether permanent residents, temporary immigrants on student visas or work visas. These protect children. These protect non-citizens. So this is a broad category of people. And it's also important to separate civil liberties from civil rights, which we'll start talking about next week. But civil rights refer to the promises of equal treatment under the law of all people, regardless of race, gender, or other personal characteristics or protected classes. Civil liberties refer more to an individual's relationship with government power. To what extent can the government do or not do something to you? Civil liberties usually stem from ideas coming out of the liberal tradition of political thought, people like John Locke, John Stuart Mill, John Rawls, Ronald Dworkin. And the idea behind this liberal tradition is that the individual is the fundamental unit of society, that we should think of individuals as having certain, as John Locke would put it, certain rights of nature or unalienable rights, as would be in the Declaration of Independence. And what civil liberties do is that they create a zone of non-interference around the individual. That since we give up certain rights to live in a society, we don't want to give up, we want to preserve some spaces of freedom and individuality beyond government power. This zone of non-interference is protected by these civil liberties. And why do we need civil liberties? Why do we need these rights? What is the kind of reasoning behind it? Well, in the liberal tradition, the idea is that you have various conceptions of the good life, or various conceptions of how people should live their lives. These can stem from different conceptions of religion, different cultural background, or just different values and beliefs about, how people should live their lives. And in a liberal society, the idea here is that the government should not prioritize any one conception of the good life because we live in a multicultural, multi-religious society. So we need to have certain things of like religious toleration and freedom of thought and conscience. These zones of non-interference where the government cannot force us to ascribe to one particular way of living a good life. Now, the original Constitution, as you know, did not include a Bill of Rights. There was no explicit Bill of Rights in the Constitution, and in fact, Hamilton, in one of the Federalist Papers, is actually very skeptical of including enumerated rights. He actually believed that the protections, the insurance of Republican governments, the kind of institutional protections and checks and balances in the Constitution would be enough to preserve individual liberty. But he was also worried that if you created like a very strict list of like 10, 12, 30 rights that the government had to respect vis-a-vis individuals, that what you actually ended up doing was creating like loopholes, right? That like, oh, well, there's not technically a right to this, therefore there is no right. And so But there were some protections in the Constitution. There were prohibitions on bills of attainder, which are basically punishment without a trial, ex post facto laws, which are basically being held by a law after after the fact, right? So that if you do something that is legal at one time, you cannot then be punished for that same activity that because it was made illegal after you had already done it. It also prohibited the suspension of habeas corpus, that if you are held by the police, if you're held by the government, they have to charge you with a crime. They have to bring the body, literally what habeas corpus means, to a judge and they cannot hold you indefinitely. However, the lack of Bill of Rights became part of the ratification debate, and many of the anti-federalist papers focused on the fact that the strong central government recommended by Hamilton and Madison did not include specific protections for individual rights. And so the Bill of Rights became a necessary part of ratification. The promise of a Bill of Rights became how the Federalists were able to secure ratification from large states like Virginia and New York. Now, the Constitution also specifically targets the federal government. The Bill of Rights includes limits to federal government action. Like the First Amendment, for example, says Congress shall make no law. And so this creates a obvious issue. Well, what about the state governments? Many state governments all have state constitutions, and those provide certain protections of rights. But what if there are different rights here? For different kind of state governments, different state constitutions. So this becomes a potentially obvious issue in which you have the states kind of working around the Bill of Rights. And so the 14th Amendment includes two clauses that try to clarify this a little bit. That includes first the Equal Protection Clause, that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. That all citizens, therefore, this means, are under the equal protection of the law, that states cannot restrict that. And second, the Due Process Clause, that nor shall any state deprive any person of life, liberty, or property without due process of the law. And so this suggests that the rights guaranteed by the Constitution should be applied to the states. And what's actually occurred is this process called selective incorporation, where court decisions basically ruled that on the basis of the Bill of Rights, on the basis of different amendment rights, that certain state actions are in violation of the Constitution, even though the Bill of Rights text itself only talks about Congress or federal action. So this is the idea that this idea of selective incorporation is that on a case-by-case basis, the courts rule that certain liberties limit state governments as well as federal governments, even though they're not explicit. And this is an ongoing process. So let's look at a few of different civil liberties that are preserved by the Constitution, and precisely because of this idea of selective incorporation. A lot of this discussion is going to focus on Supreme Court cases. So I'm going to be talking about lots of different case law because it's really through case law that the meanings of civil liberties and these rights becomes more apparent. So the First Amendment includes several different clauses, but we're going to focus on religion. And here, the First Amendment focuses on two specific clauses with regards to religion. And so let me read the text here for you from the First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And so here we have two different ways in which the freedom of religion is discussed in the First Amendment of the Constitution, the Establishment Clause and the Free Exercise Clause. The Establishment Clause is the prohibition of a state-sponsored religion, that the United States cannot establish a Church of the United States in the same way that you have the Church of England in England. And today this actually mostly focuses less on the states trying to establish a particular state religion and more of the question of the federal government or state governments favoring one religion over others. In 1971, the Supreme Court case Lemon v. Kurtzman established what's known as the Lemon Test, which is a three-part test to determine basically if the government action is violating the Establishment Clause. First, The action or law must not lead to excessive government entanglement with religion. In other words, policing the boundary between government and religion should be relatively straightforward. Second, the action or law cannot either inhibit or advance religious practice. It should be neutral in its effects on religion. That you cannot pass a law, for example, prohibiting daily calls to prayer, or you cannot pass laws that like require everyone to attend religious services on Sundays, right? Because that would be an establishment of religion. Third, the action or law must have some secular purpose. There has to be some non-religious justification for the law. That the reasoning behind the law, the justifications given behind the law cannot be purely religious in nature. They have to have secular justifications. It has to advance some sort of public good purpose, not just a religious purpose. Often these Establishment Clause cases deal with the question of religion, both in the question of do religious schools get the same type of funding, do they create, how should they be treated, as well as questions of school prayer. Can you have school-led prayer in public schools? These are much the reason why these are this question of education matters a lot is because there's always the question of authority. If a teacher is leading a voluntary school prayer, but they're in the front of the classroom, is it really voluntary? And these are kind of some of the thorny issues that the courts have to work through. The second clause here that we're talking about is the Free Exercise Clause, which is limits the ability of the government to control or restrict religious practice. So so that the government cannot limit your ability to practice your religion, as long as doing so does not violate the law in some other ways. So for example, this came to a test in the question of conscientious objectors. So some people with religious objections to serving in the armed forces, people like Quakers who are religiously pacifists, objected to being drafted or being required to serve in the armed services. And so the Supreme Court upheld the right of conscientious objectors in the case Gillette v. United States, but these conscientious objectors must be to all war, not to specific wars. So you can't say like, oh, well, I'm not objecting to all war, just this one that I believe that this is an unjust war. You cannot be a conscientious objector to a particular war. In the case Sherbert v. Werner, the Supreme Court, to go along with the Lemon test, established the Sherbert test. And the Sherbert test established two questions to determine whether or not something is violating the Free Exercise Clause. First, does the law advance a compelling government interest? The government can restrict the restriction of religious practice in ways that advance a compelling government interest, right? So, for example, if you had a religious belief that required human sacrifice. This is an extreme example, right? There's a compelling government interest in, disallowing that religious practice, right? But there's not really a compelling government interest in outlawing communion wine in Christian tradition, right? Because there's no really compelling government interest there. The law also has to be narrowly tailored. It has to be for a specific purpose to bring about a specific end. It can't just be a blanket kind of restriction of exercise of religion. Now, the Sherbert test has been kind of gone back and forth in the courts, and Congress passed the Religious Freedom Restoration Act, and this is both at the federal level, and many states have passed their own RFRAs. You might hear them at. Now, while the courts have struck down specific provisions of the RFRA, it basically enshrines the Sherbert test as law. That it puts limits on the ability of the federal government to restrict the free exercise of religion. Now, this has come into these RFRAs have come into play in recent years in very high-profile cases such as Burrell versus Hobby Lobby, in which the court held that closely held companies like Hobby Lobby did not have to provide contraceptive coverage based on the Affordable Care Act if it violated their conscience. Basically applying the free exercise clause of the Constitution to corporations. And after the Obergefell decision that they provided a constitutional right at the federal level for same-sex marriage, there are lots of questions about could individual businesses be compelled to participate in same-sex weddings and civil unions and celebrations. There are several high-profile cases about cake makers, florists, officiants who were refusing to participate and being compelled to by the state to provide their services to same-sex marriages over their claimed religious and conscience objections. And the Supreme Court held in Masterpiece Cake Shop versus Colorado Civil Rights Commission, the bake shops can choose not to provide services to LGBT couples out of concerns of conscience. So these are questions that are still being debated here today. Freedom of expression is also covered in the First Amendment, and that's kind of the remainder of the First Amendment. Again, these are, Congress shall make no law abridging the freedom of speech or of the press or the right of the people peaceably to assemble or to petition the government for redress of grievances. Now we're going to focus mostly on freedom of speech here and talk about some of the case law here. This really emerged in the 20th century with the kind of questions over free speech and assembly and petition. In the case of Schenck v. Ohio in the early 20th century, Schenck was basically arrested and charged for disturbing the peace for distributing anti-war socialist pamphlets during the First World War. The court established the clear and present danger doctrine in this decision that you just like you couldn't yell fire in a crowded theater, you could not distribute literature that was going to provide a clear and present danger or encouraging people to break the law or cause harm. This was amended in the case of Brandenburg versus Ohio, that the speech had to include a direct call to violence or law breaking. In this case, Brandenburg was fined for holding a KKK rally in which he invited the media. Which the media was invited to a KKK rally. And he sued that this violated his freedom of speech. But the court held that these rallies included a direct call to violence against African Americans, and therefore this was not protected speech. And so the courts have often held that offensive or controversial expression is protected, but what's known as the fighting words doctrine, that words that incite violence or criminal action are not protected speech. The courts have also held in a series of contemporary challenges that students have less than an absolute freedom of speech, that you do not have the same type of absolute freedom of expression in the classroom or in school as you do in the public sphere. And more recent debates, including in the 70s, of where we should draw the boundaries of free speech. In the 70s, there was court decisions over whether or not neo-Nazi groups could hold a rally in Skokie, Illinois, a predominantly Jewish suburb of Chicago, and the courts actually held that the rally could take place, but the Jewish residents of Skokie and nearby residents held a series of rallies that basically discouraged the Nazi Party of the United States from holding this rally. More recently, there's been the question about the Westboro Baptist Church protesting these funerals of fallen soldiers and of other victims of and other high-profile funerals, including the victims of atrocities and gun violence, basically arguing that these are God's punishment for the United States' toleration of homosexuality and other sinful behavior. And the courts have upheld that in the public sphere, that groups like the Westboro Baptist Church have the right to express these opinions, no matter how much harm they might be causing, psychological harm they may be causing. And so this is, again, the kind of contemporary challenge of where do we draw this boundary. Now, the Second Amendment discusses the right to bear arms, a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Now, the United States versus Miller originally held that this was linked to a well-regulated militia, and therefore that the government could regulate firearms because of this idea to regulate militia. This was later overturned in D.C. versus Heller. which argued that gun control laws that impinge on the ability for people to own firearms for self-defense and other lawful purposes violate this right to own arms, effectively overturning United States versus Miller. In the Supreme Court case of McDonald versus Chicago, which struck down Chicago's handgun ban, this basically incorporated the Second Amendment to state laws, basically saying that state laws have to respect the Second Amendment just as federal laws. Now, let's turn to the right to privacy. Now, this is not explicit in the Constitution, but is grounded in the Third and Fourth Amendments, and I'll read that text for you right now. The Third Amendment states that no soldier shall in time of peace be quartered in any house without the consent of the owner, nor in any time of war, but in a manner to be prescribed by law. The Fourth Amendment states, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oaths or affirmations, and particularly describing the place to be searched and the persons or things to be searched. And the idea here is that these provide a reasonable expectation of privacy within the home, that you have the right to not have the government agent basically take over and live in your house, and not to be searched or surveilled by the government agents. And this was actually established in a case about contraceptive law. The Griswold v. Connecticut struck down a state law that prohibited that made contraceptive use illegal even for married couples, and it basically argued that married couples had the right in the privacy of their home to use contraceptives, that this was a reasonable expectation of privacy. And this was later expanded to include all couples, that sexual privacy to include all couples. Now, sexual privacy continues to be a significant area of debate for the court. As you probably know, the case Roe versus Wade upheld the right to an abortion based on a right to privacy. That the right to privacy implied by Griswold v. Connecticut and other case law includes a right to an abortion, at least under certain criteria. Now, under Roe, there were fetal viability criteria that were based on trimesters. And basically, the court said that there could be no restrictions to terminating a pregnancy during the first trimester before the fetus was viable. Now, this was changed in the case Planned Parenthood versus Casey, which established what's known as the undue burdens test. And here, this rolled back the trimester framework of Roe with a framework that allowed for restrictions on abortion prior to fetal viability, as long as they do not create substantial obstacles or undue burdens on women seeking an abortion. And so this is where you get many states passing laws to limit abortions by requiring doctors have admitting privileges in local hospitals or certain regulations in the name of of patient safety, and the arguments that are being made is that these do not prevent substantial obstacles because they're in the name of patient safety, even as they require many clinics around the country, abortion providers around the country to close. In the case Lawrence versus Texas, the Supreme Court overruled the criminalization of sodomy and same-sex sexual relations. And beyond sexual privacy, there's a broader conception of household privacy, that in order to, and this is explicit in the Fourth Amendment, that you have a reasonable expectation of privacy within your home unless the government gets a warrant to search your home or seize property. In Knapp versus Ohio, the Supreme Court held that evidence obtained with a warrant obtained without a warrant, that's an embarrassing typo, without a warrant, is inadmissible in court. So if the search or seizure was without a warrant, it cannot be used to prosecute you. Now, the new frontier of privacy is kind of with telecommunications, and there's not a ton of case law, but this is really pressing issues since the September 11th terrorist attacks and the passage of the USA Patriot Act. The questions about how much the government can surveil you, your communications, your metadata, your web browsing history, your phone call records, your phone location data, has been an important political question. And there's not a ton of case law here, but in Carpenter versus United States, which was a relatively recent Supreme Court case, the court held that the Fourth Amendment applies to phone location data, that the police cannot just access the phone location data on your phone without a search warrant, without establishing probable cause. Now, A significant number of civil liberties deal with due process or the rights of the accused, and these are the rights basically to protect individuals when they are charged with a crime, to ensure that they are given the full due process of law and that they are not being unfairly punished. And this is the kind of idea behind innocent until proven guilty, and that we need to have a fair and impartial criminal justice system. Now, this includes the Fourth Amendment, especially Mapp versus Ohio, and the question of searches of the home, but it also, most of the Bill of Rights actually turn on these questions. So, for example, the Fifth Amendment includes a series of rights, including the right grand jury protections, that you cannot be charged with, you cannot be held unless a grand jury has indicted you, restrictions against double jeopardy, that you cannot be held, and you cannot be found guilty, cannot be charged with this, self-incrimination, not elf-incrimination, that you cannot be charged twice with the same crime once you've already been held not guilty. The freedom or the right to not self-incriminate yourself, and this was expanded in the Supreme Court case of Miranda versus Arizona, that required police to inform suspects of their right to not self-incriminate, that they have the right to remain silent and not risk incriminating themselves, and that Miranda held that if you are being arrested, you have to be informed of this right. The Fifth Amendment also included certain what's known as the takings clause, that the government cannot just take property from you without just compensation. This is less about due process and more about questions of eminent domain. Now, the Sixth Amendment includes, if the Fifth Amendment focuses on kind of the rights of the accused and how you can be charged with a crime, the Sixth Amendment focuses on questions of how trials should be conducted. It states, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and the cause of the accusation, to be confronted with witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. These are all about preserving the right to a fair trial, that you can't be held indefinitely, but you have to have a speedy trial, that this trial should be public. It can't be like a secret behind the scenes. Now, the courts have upheld that that this right to a public trial can be subordinated to the right of an impartial trial. If it was public, that could, especially for high-profile cases, that could inflame the passions of the jury. And the idea that you are going to be tried by an impartial jury of your peers, which means that you have the right to challenge the impartiality of jury members. You have the right to confront witnesses and to compel information, compulsory process for entertaining witnesses, that you have the right to make a legal defense, that it's not simply the prosecution making their case and then the jury decides if you're guilty, if they have made their case or not, but that you can challenge the evidence that's brought against you, that you can confront the witnesses claiming that you have committed a crime and present your own witnesses. And you also have the right to a legal counsel. You have the right to legal representation, which the Supreme Court in Gideon versus Wainwright held that this means even if you cannot afford one, that you have a right to a public defender if you are charged with a crime and cannot afford legal representation. The Seventh Amendment includes certain protections for civil suits. In suits at common law, where the value of controversy shall exceed $20, the right of a trial by jury shall be preserved, and no fact trial by a jury shall otherwise be examined in any court of the United States than according to the rules of the common law. So this implies two big ideas. First is that you have the right to a jury trial in certain civil cases when the scope is high enough. And additionally, that the separation of matters of law versus matters of fact means that when you appeal the case, that you are not appealing, and we talked about this in judicial review, the facts of the case. You are appealing whether or not the law was correctly interpreted or if the law is valid itself. That judges do not evaluate the facts of the case, that judges evaluate the law. This is preserving the common law tradition. Now, the Eighth Amendment deals with questions of punishment. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. So again, bail is the there is a right. The states can require you to post bail to ensure that you will show up for your trial and not just flee the jurisdiction and avoid being punished for your crimes. But this Eighth Amendment holds that you cannot be held excessive bail. That you have the right before you are convicted of a crime to all of your rights. Now these can be restricted based on the severity of the crime, right? If you are being charged with murder, you might be held with a very high bail or without bail. If you are a flight risk, you might be held or required for home monitoring while you await your trial. But the idea here is that there should be a balancing test on how much bail you're held by. It also includes prohibitions of cruel and unusual punishment. And this means prohibition the use of torture as a form of punishment and certain forms of execution, including the firing squad. Now, there's a current debates about the death penalty more broadly in terms of both the manner and for whom the states can put to death. There's debates over whether or not certain forms of lethal injection that were untested or without certain parts of the chemical compounds that provide a paralytic and sedative are in fact cruel and unusual, as well as whether or not people with mental disabilities can be executed by the state if that was cruel and unusual punishment because of their personal mental state. And this is kind of the current terrain of that debate. So I want to close, and we're going to talk, and I'm not going to talk specifically about the Rosenberg and the Roe v. Wade readings from the PP Reader, because that's what you all are going to talk about in your discussion threads. But I want to set that discussion up. I want to talk about the politics of civil liberties. So we tend to think of civil liberties as a kind of trump claim. And the philosopher Ronald Dworkin talks about rights as trumps, that these are a claim that around this that the government cannot penetrate beyond this inviolable walls, right? So that no matter what, the government is restricted from violating certain liberties, right? These present an inviolable wall around inviolable wall around the person protecting us. However, these are always political. These are a claim upon the government, a demand that some rights be upheld or respected. And the meaning of these rights, as we've already talked about, the fact that we have different case laws changing the meaning and applying different tests to determine what these rights actually entail, is because of the debate over the meaning of these rights and liberties is contested, that there is not universal agreement over what freedom of speech means or what the implied right to privacy entails. And so you have different actors in state and federal governments trying to either kind of constrict this boundary, right, make it smaller, increase the scope and breadth of state power, or expand this boundary, pushing it beyond, expanding this realm of inviolability of individuals beyond what they currently are. And because there's this debate, and you have different in a federal system, you have different states and jurisdictions kind of testing the waters and testing the boundaries in different ways. Individuals then have to appeal to the courts, and the courts are ultimately where they settle and negotiate these rights claims, right? This is the kind of argument that Hamilton makes in the Federalist that you read last unit, that in order to preserve a limited constitution, right, you need and preserve the liberties and rights of the people, you need to have an independent judiciary. Now, we've already seen that the judiciary is not really as apolitical as we said, but when we're talking about liberties, rights, and rights claims, that the court ruling doesn't settle things once and for all. That once the court rules something, there still has to be statutory incorporation. Famously, in the question of abortion in Roe versus Wade, there is not a federal law preserving the right to abortion. It's all state by state regulations. And so here, like the fact that there's no federal statute actually kind of means that there's a lot more contestation over the meaning of abortion, meaning of the right to an abortion. There's also incorporation at the state level. When we talk about Brown versus Board of Education next week, when we talk about civil liberties, many states actually resisted the institutionalization of desegregation, that they tried to maintain segregated schools despite the Supreme Court ruling that segregated school systems were unconstitutional. So you have different incorporation at the state level. And you also have like what we talked about last week, 2 weeks ago, with the politicization of the courts. And this can be anything from, oh, the courts have made rulings that we don't like. I'm going to push my, I'm going to try to elect a president who's going to appoint justices to the federal judiciary that agree with me more, right? And so that the courts are often a question, or a political question here. But just because the court makes a ruling, that there's still going to be contestation over the ruling, and then we're back where we started. And this is what you are seeing at like the state-by-state regulations of abortion. So keep this kind of general framework in mind when you read the Roe versus Wade opinion, and also the Rosenberg reading, and you write your discussion post for this topic. So on Wednesday, we're going to be talking about immigration and citizenship, looking at some readings that are not from the textbook. They're both on Moodle. May Nye's The Strange Career of the Illegal Alien, and a more recent piece on federalism and state changes in immigration policy. So for today's discussion thread, looking at both the opinion and dissent from Roe versus Wade and Rosenberg's analysis in the Principles and Practice reader, describe how the right to privacy and the right to an abortion has been and is politicized. What implications does this have for civil liberties more broadly? How is this right bound up in political debate and contestation? Now remember, you have till Friday at midnight to post a 200-word post to one of either this thread or the next thread, and then you have till Sunday at midnight to post a 100-word reply to one of your peers' posts. So that is it for our discussion of civil liberties. I hope that this was helpful for you. If you have any questions about the material, any concerns about accessing the material, or anything that's come up and preventing you from completing your assignments, don't hesitate to reach out via email or drop into office hours and chat. I hope you all are staying healthy and well, and I will see you next time. Take care.